faced a lot many strikes also at that time. So there will always be, new learnings with the new codes. So what I have tried to do, first I'll try to give you an overview of the laws. There are so many regulatory requirements that we have to comply with. And there is no end to it. I mean, there are more than 200 laws or regulations or statutory provisions for which we have to, comply day in and day out. So I have tried to enumerate some of them, and will just touch upon them before I delve into the some of the acts that are mentioned in the manual and discuss about them. So there are regulations that are, I have clubbed them or classified them into these headings. For example, there are legislations related to the professional code of conduct, ethics and etiquettes, professional education and training, management of patients, biomedical research. Then there are laws pertaining to commissioning and management of hospitals, management of human resource, supplies, equipment and blood banks, environment protection, public health laws, for example, during the uh, 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 pandemics and epidemics, and the medical legal aspect, and then the business aspect of the healthcare. We have to, comply with those provisions. For example, the simplest is the GST Act or the Income Tax Act that we as a hospital also need to comply to. So with respect to the professional education and training for the medical education in this country is governed by the National Medical Commission Act. Earlier it was called the Indian Medical Council Act, IMC, and the Indian Medical Council and the IMC Act of 1956, if I'm not wrong, or maybe 46, that I need to check. Sorry, the 1956, yeah, the Indian Medical Council Act of 1956. Some of the provisions of Indian Medical Council Act 1956 are still, relevant here. We'll not deep dive into it, but just for the information I'm telling you. For example, the Indian Medical Council Professional Conduct, Etiquette and Ethics Regulation of 2002, they are still applicable because the newer ethical rules that were being formed have been kept in abeyance after some of the controversies that happened. National Board of Examination rules for the DNB training in the country, the Dentist Act of 1948, the Indian Nursing Council Act of 1947, the Pharmacy Act of 1948, the All India Council for Technical Education Act of 1987, the National Commission for Allied and Healthcare Professions Act of 2021. So these are all the acts that we have to keep in mind when we are hiring different types of staff in the hospital. Then there are acts related to the management of patient. MTP Act of 1971, which I'll discuss, the Transplantation of Human Organs Act of 1994, and it has been actually amended from time to time. The Mental Health Act of 2017. There are acts related to the medical record, the RTA Act of 2005. It's only applicable to the government hospitals or the trust hospitals or the hospitals which are having a significant contribution from the public exchequer. Telemedicine practice guidelines were made during the pandemic. In fact, I am a fellow of the Telemedicine Society of India, and I'm a member of it for last almost 15 years, or maybe more, maybe 19 years. Earlier, there was this discussion that people did not want to regulate the telemedicine practice because they felt that by regulating it, we would not be, allowing it to flourish. Whereas when the pandemic struck, people immediately felt that if there are no guidelines or regulations, these could be exploited. And that's why those guidelines which were already available and were not being notified were then actually being notified. The Assisted Reproductive Technology Regulation Act of 2021, the Protection of Children from Sexual Offences Act, that is popularly known as POCSO, of 2012, the PCP-NDT Act, which has been amended from time to time, and not to forget the Consumer Protection Act. Biomedical research related statutes are National Ethical Guidelines for Biomedical and Health Research involving human participants of 2017, was actually prepared by ICMR. National Guidelines for Ethics Committee reviewing biomedical and health research during COVID-19 pandemic, the ICMR policy on research integrity and publication ethics, and the national ethical guidelines for biomedical research involving children. So these are relevant if you are a research organization like us, where a lot of research is also happening along with the patient care. Now, commissioning and the management of hospitals. Societies Registration Act, if your hospital is a society, is under Societies Registration, and the Companies Act of 1956, Atomic Energy Act of 1962. If you have those departments which are actually using the radiation, for example, the radiology department, radiotherapy department, or nuclear medicine department. Electricity Act, National Building Code of 2005, very important. From the full planning, you need to ensure that your architecture is compliant to the NBC and you are not violating any NBC provisions. Radiation protection certification from the BARC is required in Indian Boilers Act of 1923. Then the state-specific fire safety regulations and the electricity rules that differ from state to state. Management of human resource, a lot of it is now clubbed in the the labor codes. So all these have now part of the labor codes, except for ESMA, I believe. Minimum wages, contract labor, ESI, EPF. Although ESI and EPF are still there, but they have been subsumed into the labor codes. But for example, there is now a discussion that, for example, the EPF Act, to be eligible right now, the maximum wage that can be there right now is 15,000, and for ESI it is 21,000. That means if your monthly wage is 15,000, you are not eligible. More than 15,000, you are not eligible for EPF subscription, and if you are having a wage of more than 21,000, you are not eligible for an ESI. But now Supreme Court recently have directed the government, because these limits were decided almost 12-13 years ago. Last revision was in 2014, if I'm not wrong. So in 12 years, these limits have not been revised. So government is actively revising now the limit for EPF and would probably increase it from 15,000 to 25,000. And the newer labor codes have actually redefined the wage. The definition of wage has also been redefined, and I'll discuss when we discuss these codes. So many more people may be now eligible for the EPF contribution because the definition of wage has also changed. So as an administrator, we should be aware of these things so that we are not, violating whether the EPF Act or ESI Act. Then the employees exchange, if you are advertising the vacancies. Maternity Benefits Act, Persons with Disabilities Act of 1965, Indian Trade Unions Act, Indian Industrial Dispute Act is subsumed in the Labor Code, and the ESMA Act of 1981, the Essential Services Maintenance Act. And then there are requirements for supplies, equipment, and blood banks. The Drug and Cosmetics Act of 1940, very important. And then the NDPS Act of 1985, the Narcotropic Drugs and the Psychotropic Substances Act of 1985. The blood bank regulation under the Drug and Cosmetics Act. Because blood is considered as a drug, even the MRI is now under the Drug and Cosmetics Act. So MRIs are now being regulated through the Drug and Cosmetics Act. The excise permit to store the spirit, the Central Excise Act of 1944. Every year you have to, go to the excise commissioner and get the quota for your hospital approved. Similarly, for the NDPS, you have to have a possession permit every year, and you will say, okay, these many morphines I need, these many pethidines I need, for which they will give you what we call the permit and a possession permit, and then they will give you a transport permit every time you want to transport it from the manufacturer to your hospital. And then the Drug and Magic Remedies Advertisement Act of 1954. Then acts related to environment protection, the Environment Protection Act of 1956, and under that are different rules and regulations, whether it is Biomedical Waste Management Amendment Rules of 2018, Atomic Energy, Noise Pollution, Water Prevention and Control of Pollution Act of 1974. Now we are generating a lot of e-waste also. So we have the e-waste management rules as well. So that also we need to take care of. The laws governing the safety of patients, public, and staff within the hospital premises, the radiation surveillance procedure for the medical application of radiation 1989, radiation protection rules, Arms Act, Boilers Act, Explosive Act, Gas Cylinder rules, Insecticide Act, Prevention of Food Adulteration Act. Because we are supplying milk, food, different types of diets in the hospital. So we have to be careful that in even inadvertently we are not violating the Prevention of Food Adulteration Act. The public health laws, the Article 21 of Indian Constitution, which gives the right to life, because there is right to life, and it has Supreme Court has given a decision that the right to health is enshrined in the right to life itself. Although there is no separate right to health, but it is enshrined in the right to life. Then international health regulations of 2005, you must have heard a lot about these during the 2020 pandemic. Then Epidemic Diseases Act of 1897, Anti-Mosquito Breeding Laws, Cigarette and Other Tobacco Products Act, the Prohibition of Electric Cigarettes, Prohibition of Smoking in Public Places, Food Safety and Standards Act, and there are so many others. And for example, the Motor Vehicles Act. If you are buying, for example, an institute like ours, we have almost a big fleet of more than 60, 70, different types of vehicles, starting from buses to smaller cars, etc. So we have to be compliant to this act also. Other acts related to food safety, these are there. You can have a look later on. And then the laws governing to the medical legal aspect. And one of the important one is the Consumer Protection Act of 1986. And I don't know if you have come across very recent decision of Supreme Court just a few days back, in which the Supreme Court said that even if the doctor has died, and if the court decides that there is a compensation award to the plaintiff, that compensation can be recovered from the legal heir of the deceased doctor within the limits of the estate that has been transferred from the doctor to the legal heir. That means even if the doctor has died, that compensation can be recovered from his or her children, and limited to whatever those heir have received from the doctor. So I mean, I don't know what will happen, but even if the doctor has died, that compensation can still be given to the plaintiff. So we will discuss a little bit of Consumer Protection Act in the subsequent slides. So then the Indian Evidence Act, the law of privileged communication, I'll just share something about that also, and the law of torts. I mean, this is entirely a different whole chapter for the law of torts. To discuss a different class is needed. Then the laws governing the business aspects of the hospital, Charitable and Religious Trust Act, Contract Acts, Copyright Act, Customs Act, Income Tax Act, the Insurance Act, and the Central GST Act of 2017. Now with the Bharati Nyaya Sanhita, which has replaced the old IPC, there are a few provisions that are applicable to the healthcare industry. For example, the Section 271 is about the negligent act likely to spread infection or disease dangerous to life. And 72 is about malignant act likely to spread infection of disease dangerous to life. And then there are penalties also, mentioned in the Bharati Nyaya Sanhita for these violations. Section 273 is about disobedience of the quarantine rule. 274 is adulteration of food or drink intended for sale. Section 275 is sale of noxious food or drink. 276 is adulteration of the drug. 277 about the sale of adulterated drug. 278 is sale of a drug as a different drug or preparation. That means the spurious drug you are trying to sell. And Section 280 about making atmosphere noxious to health. So any type of pollution to the atmosphere which is noxious to health is also punishable under the Bharati Nyaya Sanhita of 2023. Now, Let's discuss a little bit about the Consumer Protection Act. And you might be aware that the landmark 1995 judgment of Indian Medical Association IMA versus VP Shanta. Before that, because the Consumer Protection Act came into force in 1986. Between 1986 to 1995, the healthcare industry was not covered under the Consumer Protection Act. It was only with the judgment of IMA versus VP Shanta that the healthcare industry was brought into the ambit of the Consumer Protection Act. So before that, it was not there. So the bottom line is that you are not just healer. Yes, give me a moment. Under the eyes of the law, you are a service provider bound by a legally enforceable consumer contract. So Section 242, 242, Section 2, subsection 42 uses an inclusive definition that definitely captures medical practice. Is the service completely free of charge? If yes, it is excluded from Consumer Protection Act. But if it has been, cross-subsidized, if someone else is paying for, although you are getting it for free, but in some way someone else is paying, then it is included under the CPA. And what type of personal contract is? The contract of personal service is excluded from the CPA, but the contract for personal service that is covered under the CPA 2019 is service provision depending on skill, knowledge, and discretion. The doctor-patient relationship comes into that. So the bottom line is that even though health services was dropped from the final text of the 2019 Act, because in 2019 the CPA of 1986 was repealed and the CPA of 2019 came into force. So although the health services as such is not mentioned, it was not mentioned in the 86 Act and it is not mentioned in the 2019 Act, but the legal definition of the contract for personal service completely encompasses the medical practice. So we are still in, as per the 2019 Act, part of covered under the Consumer Protection Act. Some comparison between the 1986 Act and the 2019 Act. The filing jurisdiction in 1986 was restricted to the seller's office location. Now it can be done anywhere in the country. Court fee, there was standard fee required for all claims. Now zero fee for consideration under rupees 5 lakh. If the claim is for under 5 lakh, no fee is to be submitted. Logistical access in-person physical filing was the only way in the previous act. Now e-filing has been enabled with the more and more digital footprint. The definition of deficiency, standard definition of clinical negligence was in the 1986 CPA. It has been expanded to include deliberate withholding of relevant information as well. So patients no longer need to travel to your jurisdiction or pay filing fees for most routine claims, vastly lowering the barrier to entry for the lawsuits. Now it has become more easier to file a lawsuit if there is grievance on the side of the patient. Basing jurisdiction on considered paid forces massive claim into understaffed district commission. Now, actually, what was happening in the earlier, the jurisdiction was based on compensation claim. So for 2 crore, national commission was there. Now, under 2019 law, jurisdiction based on the consideration paid, that is rupees 2 lakh. So district commission now handle compensation up to rupees 1 crore. So there is, and in addition to that, there is this mediation, what you call the mediation cell have been created. So if someone files a case in the district forum, if it involves a grievous hurt or not is to be seen. If there is no grievous hurt, then these cases are being diverted to the alternate dispute resolution under section 74. That is, a mediation cell has to be created at all the districts, which will first see all these cases and try to settle them. If they are not settled, then only they will be taken to the district court where the mediation is excluded or failed and can then proceed directly to the protracted litigation. Now, the deficiency of the definition of the deficiency is now aggressively polices administrative and the communicative lapses. For example, if you have not provided a receipt to the patient, that can also be based on that they can also take you to the consumer forum. The consultation notes, the consent has not been taken, or the breach of patient confidentiality is now explicitly codified as a ground for litigation. And these all things are mentioned in the newer CPA of 2019. One more thing that we have seen over the period is that now the courts are giving compensations. The scale of compensation has increased. Earlier, it used to be a few lakhs to 50 lakhs or something. You must have heard about the famous Dr. Kunal Saha's case where he was fighting for the negligence that led to the death of his wife, in which almost 11 crores of compensation was finally awarded to him. And this is not just one case. There have been many other cases where the compensations have been awarded in the tunes of crores of rupees. Now, there is one unintended consequence of CPA also. Now, CPA is good where the deficiencies are being, brought to the court and the justice is being given. But the unintended consequence is the defensive medicine. And defensive medicine ultimately leads to higher cost for the patient. Now, the doctors, you know, uh, hesitate to take the complicated cases many times. They want to refer it to the higher centers. At the same time, uh, they try to make sure that the diagnosis is correct, and to do that, they many times have to, get more tests done. So this defensive medicine is an unintended consequence of the CPA. Uh, this adds a proactive watchdog to an already crowded regulatory environment. Uh, Earlier, see, the medical practitioner is already, as I mentioned, governed by so many laws, whether it is the Medical Council of India, State Medical Council, then the National Human Rights Commission, also the Clinical Establishment Act, and many others, as I mentioned. On top of it, and medicine is not a perfect science, where two and two is not always four, right? There are things beyond the control of a healthcare provider or a hospital, and there are known complications also. And many times, the adjudicating bodies are not well versed to understand the nuance of the medicine. And that is where the problem arises. When although I must say that the courts in this country have been very good, and they do not award just based on suspicion. There are solid grounds. Then only they are awarding these compensations, but the process sometimes may take a longer time. Unintended consequences, as I mentioned earlier, also the defensive medicine is certainly, and it leads to higher cost, not just for the patient, but for the whole health system per se, especially when we are already resource constrained. Uh, I always say your best defense is your documentation. If you are doing good documentation and you have counseled the patient very well, and if you have told them what is the what is being done and what are the limitations of your intervention, you're not giving false hope to the patient that everything will be good. You tell them that here are the things that I want to do, here are the limitations to them. Things may also go wrong. So that frank communication is very important. So at the personal level, the doctors should implement mandatory digitized billing and receipt system, upgrade informed consent protocols to prevent unfair trade allegations, and establish stringent tech and privacy standards for all telemedicine consultations. But I again emphasize it is the documentation that will save you in the court. Informed consent is one of the most important document in this. And when I say informed, it has to be informed and not just merely you're taking a signature on a piece of paper. patient should be made aware, or if the patient is unconscious, then the family members of the patient should be made aware what we are doing, what are its limitations, and what could go wrong. And then the systematic safeguards, expand physical and human resources at district commissions because too many cases are being filed, introduce strict financial penalties for filing false or frivolous complaints. This do actually happen many a times, where if the courts find that this is a frivolous complaint, they actually impose cost on such complainants, and provide mandatory compensation for loss of earning to doctors found not guilty. Now, this is not going to happen, but I mean, this was I have taken from one of the paper that was published in the Indian Journal of Medical Ethics, where they have argued for such type of a provision. Uh, Privileged communication. Now, this is something we should understand when we are talking of the medical legal aspect of the healthcare. Uh, Confidentiality is the professional secret which you cannot divulge. Now, when patient is coming to a doctor and sharing the information, this is something we call a fiduciary relationship. A fiduciary relationship is a relationship of trust, where the person is sharing the information with another person with the hope that that information will only be used for my benefit, and information will not be used in any way for any other purpose. So for example, if someone is sharing the, let's say, smoking history with the doctor with the only hope that that information will be used for the treatment that is to be provided to me, or for example alcohol history, or the high risk behavior, or any other past history the patient is sharing, that has to be kept confidential, because that information is only shared with the purpose to provide benefit to the patient, right? And this type of a communication we call is being communicated in a fiduciary relationship. So information obtained in confidence, divulging this breaches moral and legal obligations, leaving the practitioner liable for damages, right? But then there comes the privileged communication, where there are legal exceptions. For example, let's say there is a case of chickenpox in a medical college hostel, right? Now, that particular student has a right that his condition should be kept confidential, but at the same time there are health concerns of maybe hundreds of other students that are residing in the same hostel. So in those situations, there is this provision of privileged communication, where a doctor must disclose bona fide information to authorities to protect the larger public interest. And that happens during the pandemics or epidemics, where we even have to restrict the movement, because otherwise we can't restrict the movement. We are in a free country, but we impose restrictions for the larger public good, and these restrictions should be commensurate to the risk that it is being posing on the society. This cannot be a disproportionate restriction on the freedom of a person. So these privileged communications we need to understand. And this fiduciary relationship we also need to understand in terms of the RTI Act of 2005 also, because many times people demand for the medical record of patients other than themselves, right? We cannot provide them those, and I'll discuss the section 81E, which clearly bars from divulging the medical record to a third party under the Right to Information Act. Consent is, as I mentioned, the documentation will save you, and the consent is the most important. So one is the implied consent. Implied consent is if a patient is coming to your OPD and he's putting his arm in front of you to take a BP, he has implied that, okay, doctor, you can take my BP and record my BP. That is implied consent, for which no formal, written consent is required. And then there is oral consent, and then you just advise to them, okay, you go and take the tablet, or you get these diagnostics done, for which if there is no invasive procedure is being done, for example, if ultrasound is being done, those all things are done on the oral consent. But expressed informed written consent is required wherever there is an intervention, admission, etc., an operation, or even a diagnostic procedure which requires some time of which has invasive procedure is required. For this, we have to have a written informed consent along with the signature of a witness also. So in an informed consent, always take a signature of the patient if patient is conscious and understands and is not a minor, right? So it has to be more than 18 years of age. Below the 18 years of age, we take the consent of the legal guardian. Or in the emergency situations, for example, if an emergency arises, if some accident happens and the patient has been brought to the hospital, then the doctor becomes the legal guardian till the time their actual guardians or parents or the family members arrive. And in the interest of the patient and saving the life, that doctor can take a decision, and that is completely valid, right? Doctor can't say just because patient is unconscious and the family members are not there, I will not perform an operation because I need an informed consent from a family member. In those life-saving situations, doctor can perform these. Doctor can, document the situation, circumstances, and why this decision is being taken in a fair manner, and take the approval of the administrator, and then can go ahead and perform the operations. Now, Right to Information Act, we need to understand that in this act, and it's a wonderful act, let me tell you. Before 2005, it was very difficult from many of the government organizations to get information. It has made things much more easier. And I always say in the healthcare that the providing the information should be the norm, and refusing it should be an exception, and the exceptions that are mentioned in the act. And the beauty of this act is one of the smallest acts. And for the healthcare, there are very few provisions that are we should be aware of. And I take a full class on this, and we have done the workshops on the Right to Information Act for the PIOs. For the uninitiated, I want to tell that in this, you can just file a application, submit 10 rupees of your RTI fees, and it is not required if you are a BPL or some other category where you don't require to submit a fees. And with this only, you can get information at your home by a registered post. But then there are limitations also. And those limitations as an exceptions are written in the section 8 and section 9. And to us, the most important is 8.1e. I have forgot to mention it here, which is related to the fiduciary relationship. 8.1e says that if the information has been collected in a fiduciary relationship, that is exempted from disclosure under this act. You don't have to do. So medical record, you cannot disclose to any other person, even to the spouse. We receive many a times where the husband submit the application, RTA application, asking for the medical record of the wife, which was admitted. I tell to them, you get an application signed from your wife, and we will send the information to the address. But we cannot give it to you, and the vice versa. So many a times, people come that my grandmother was admitted, and I have to inform. It has to be the grandmother should be the applicant. After the death, you can provide this information, the medical record, because it is required many times for insurance purposes also, to the legal layer, for which you have to take a undertaking on क्या कहते हैं जो stamp paper. So you have to take an undertaking on the stamp paper, and you should have an SOP in your hospital. How will you be, if you are a government hospital, how you intend to provide this information, what is in, and what are the documents that are required, stamp paper, declaration, then maybe an Aadhaar card or an valid ID, etc., etc. Uh, the medical records are very important in a hospital, not just for the patient care, research and planning and public health, but for your legal protection. So, and these are the only things that are, the medical record is the only thing, documentation is the only thing that is going to protect you in the court. So, documentary evidence for proficiency, CPA defense, and the medical audits. The patient care ensures continuity of care, prevents duplication, aid health insurance claims. Now, government's emphasis is that all the citizens of this country should have an ABHA ID. So Aishman, under the Aishman Bharat ABHA IDs are being created in the different, because different health systems have, different type of HIS, and those HIS don't speak to each other. And some of you must have heard of the HL7 standards for the HIS. So the government is trying that uniformity in the medical records so that there is portability of medical record. If you go from one state to another state, one hospital to another hospital, you don't have to carry it in your pen drive or in your, in the physical form. And then it will not be lost as well. If it is, kept on a server or with the ABHA ID, you can, retrieve it on later on. And then there are restrictions on who can retrieve it and with what consent is required to retrieve it. And then these retention policies are also important because the space is limited. If you could digitize your physical record, there is nothing like it. We have digitized a record for the last almost 15 years now in this hospital, which can be kept for perpetuity. And it is not just the digitization, then you have to do a codification also so that you can search it later on, right? Whether then this indexing would be done for different parameters that you identify, so that, if it is a PDF, then you have to have this indexing. If it is a HIS that you are, creating by entering in the HIS, then probably you don't need the cipher indexing. Another thing is that there is this ICD codings that are done for different type of diseases in the hospital. That is also an important part of the medical record. So retention policy, you can have your own retention policy, which is, approved by the competent authority in your hospital. MOHFW has said that 3 years for the hard copies and IPD sheets, 5 years for OPD, and 10 years for the medical legal record. In our hospital, we keep medical record beyond 10 years also, just in case it is required. Now, because it has been digitized, so it can be kept for perpetuity. As I mentioned, for us, it is the valid, informed consent, rigorous medical records, and the profession medical records that will save us in the court of law. So it is very important that we have quality procedures, we have robust quality control, quality assurance, or TQI program in the hospital. If we could go for accreditation, there is nothing like it, because it not only gets you a certificate, it actually inculcates a culture of, thinking about quality, working towards quality in your organization, and legal awareness among the administrators, and where you can actually inculcate in form of some workshops or seminars you organize for your clinicians, where you make them aware about the CPA. For example, in our hospital, we do a CME on laws applicable to hospitals, laws applicable in healthcare. Similarly, you in your hospitals or in your workplaces can, organize such CMEs for doctors, where they are made aware for what are the, legal positions, what are the newer things that have recently happened, and what are the requirements, what are the expectations from the doctors, administrators, nurses, etc. The Medical Termination of Pregnancy Act, MTP Act, I'll tell you in a very brief, and this is the most important slide to remember. And in 2021, it has been changed from the 1971. So now up to 20 weeks, the termination can be done with the opinion of one RMP, that is a registered medical practitioner. From 20 weeks to 24, it is done with the opinion of two medical doctors or RMPs. Beyond 24 week, for substantial fetal abnormalities only, it can be done with a state level medical board. Because earlier what was happening, people were going to the court all the time, and then the courts were actually sending them to the bigger hospitals, and courts were inundated with these types of requests beyond 24 weeks. So courts actually asked the government to look into it, and then the government came up with these amendments in the 2021. Now this state level medical board uh, is constituted by the state health authorities. You would find that some of the states don't have that, and then the gynecologists sometimes are struggling. Where should we send those mothers or ladies who have these fetal abnormalities and want to get determination? These are the special categories eligible for 24 weeks: sexual assault, incest victims, minors, women with physical disabilities, mentally ill women, up to 24 weeks. Then cases involving substantial fetal abnormalities, as I said, they can be done beyond 24 weeks also, and women in disaster emergency situations. PCPNDT Act, it's very important, and the latest amendment was of the 2003. And the important thing, key provision is the record maintenance in your hospital for PCPNDT. There are two, three things. Number one, wherever there is this ultrasound machine, there should be a board stating standard languages there that the sex determination is not done here. That is first thing. Registration of your facilities obviously has to be done. Third is the record maintenance and the monthly reporting that you have to send to your competent authority of the state under the PCPNDT Act. And whenever you are purchasing, or even if you are shifting your sonography machine from, let's say, one place to another, one room to another, you have to have the permission of the competent authority of your area under the PCPNDT Act. So keep them under the loop, keep them informed. If you're buying a new, you first have to get the license for that ultrasonic machine. And even the probes that you are purchasing, not just the machines, the probes, you cannot just lose those probes. So you have to, when you're condemning those, the condemnation of those probes is being done, that has to be properly documented and informed to the competent authority and take approval for those condemnations. So when they come for inspection and they don't find one of the probe is missing, this could be a very problematic situation. So that is all from my side with respect to the unit 12. If you have any questions or comments, I'm happy to take, and we are almost 350, so I don't think we would be able to cover the unit 9 and 10. But any questions, any thoughts, any experiences?
Small query from my side. Actually, I have gone through the books. So where that IMA versus BP Santa, the Supreme Court judgment, they have mentioned 1996. So is it by error, or we should go by 1995 only?
Let me recheck. I'll recheck and come back to you. Maybe there is some error.
This book is with me, sir.
Okay, yeah. Okay. Because IMA versus VP. For the reporting purpose, I think we mentioned when it was. See, it was on 13th November 1995. 1995 is the correct one.
Okay, so we should write 1995 only, no, sir?
Yeah. So you can search on the Google, and I'm looking at the India Qanun, the IMA versus VP Shamta and others on 13th November 1995. Maybe I'll recheck and come back to you.
Yes, sir. I am reading from the book itself.
Okay.
A landmark judgment was delivered by Honorable Supreme Court in 1996 in the case of Indian Medical Association versus VP Santa and others. Civil Appeal number 688 of 1993, wherein the following decisions were made. So it is clearly.
I'll recheck and come back. Okay. because there seems to be some confusion. So I'll recheck and come back to you. Okay.
Yeah, I being the administrator of the hospital,
Yeah.
so about that medical legal records maintenance, that is also if it is MLC, because recently I got a call from the court and that was 15 years old. So I think MLC cases, this was a general rule that it should be maintained for perpetuity. Though the CGSS and all those say it's for 10 years or so, and if the you know how slow the courts in India run. So just recently, few days back, we got a call from a court for a neurosurgeon who is working here, and he had to go, and obviously it was with us, so that's why we could provide the cases.
Yeah.
Yeah, and secondly, one
That's
thing, sir, about the MTP Act also 2021. So in rape cases, is it allowed after 24 weeks also? As the
no.
conditions, I am telling you,
No, it is only for the fetal abnormalities.
only for fetal, not for rape.
No, for that you have to go to the
This
court.
book again mentions the same thing because I had gone through the book before coming to your
I
class.
I don't think that the original act allows it for that, but
Sir,
because this is so vast thing,
uh,
so covering everything in the 2 hour was not possible. So I'll
yes, yes.
recheck. Maybe
So I think you
I'll,
can note these points, and then
yeah.
we'll circulate this to the students. Not an issue. We'll just get back after going through these points.
Will you take one more query, sir?
Yeah.
Yeah.
Please go
Before
ahead.
that,
About the
Madan
Digital
Mohanji,
Personal Data Protection Act of
Madan Mohanji,
2023.
Madan Mohanji, hold on. Before that, I will request the students. We have posted a link. Please
No.
fill your post test and review. Please fill that. Hanji, Madan Mohanji, आप पूछिए.
DPDP Act, you were asking something. Go ahead.
Yeah, 2023 it came, but operationalized in 2025 only. So they have put a very stringent penalty systems before divulging any information about the patients to others. So this is just for information to others, sir. I think you are already knowing it
I
all.
am I am already working on it. I am working on a paper on it, and for information, because you have asked about this. So there are two things. One is the DPDP Act, and then in 2022 there was this the digital health policy under the Ayushman Bharat also was there, which was even stringent than the DPDP Act. But the domain of that policy is only the hospitals who are collecting the data for the Ayushman Bharat and not beyond that. So, but this DPDP Act is applicable to all data and not just the healthcare data.
Yes, right,
There are
sir.
so many good things in this act, I must say, and then there are a few concerns also. So, but as I said, it's a large topic and requires entirely. This will also require entirely different class. But I'm working right now on a viewpoint paper, which I will either send to a newspaper or a journal once it is finalized. Yeah,
Yes,
that
sir.
was a good point. Yeah,
Share with
Okay.
us also, sir.
sure, certainly.
Any more questions from anybody else, please?
Sorry, madam, if I have gone over the board
No,
today
it's
also.
okay.
मैडम एक बार मेरे पे गुस्सा हो गई थी.
Ma'am,
Hi, ma'am. Good afternoon. Could you please share the link again?
Yeah, I will share the link. Yeah. Any other question?
Thank you.
Somebody was
Yeah,
going
ma'am.
Yeah.
Can we get the PPT of today's class, ma'am?
Yeah, we will. I think if sir will allow, we will send it.
No, fine with me. Yeah, I'll give both the PPTs.
Take care, sir.
Yeah.
Thank you.
Thank you, ma'am.
I'll share with them with Dr. Rita on the
Sure, sir.
WhatsApp.
Email.
If that is fine. Okay. I'll email. Yeah.
Anybody has any other question? Your own experiences, how you have dealt, you can also share that with others. And how do you think that now the knowledge that you have been given today, maybe you will be acting differently? You have become more wise, maybe. So that also you can share if you want somebody's experiences that you have dealt with patients? You had doubts earlier, but now you have more clarity. I'm sure you have more clarity on all these issues now. So no questions?
Good evening, ma'am.
Yeah, please.
Could you please share few journal names for hospital administration?
Sure, I will do. Sure.
Thank you. Thank you, sir.
Yeah, but just for your information, it is very good to have extra knowledge. But for your examination point of view, your books are more than enough. Okay. Of course, extra reading is always encouraged, and we'll be happy if you would like to further. But don't get worried from the point of view of examination. Okay.
Yeah, and as I mentioned at the start of the lecture, I don't know if you had joined by that. IGNOU manuals are one of the best. One of the best, I'm telling you, because there are not, unfortunately, it is our lack. There are not many good books on the hospital administration. And we still rely on these manuals because so many experts have written them, so many people, and they have been revised from time to time. One of the best manuals are there for the hospital administration.
Thank you. No, and another thing I want to say, Kesar, that for every, especially in the medical field, there are so many, two versions of the same thing.
Yes.
So in the examination, please don't try to quote any other journal or any other book, because we will stand by what we have written in our books. Of course, it may be a little outdated, maybe by the time, because we take 2 years to complete the book, but then as and when they will be revised, then the things will come. But from examination point of view, you can always defend your answers as to that this is what had been written in our books, because that is what is available to you, available to everybody. Okay. And we will be happy if you bring it out to us, like Madan Mohan ji is brought ke ye book mein ye likha hai, so we will like to go through it, and if it is requires some updation, requires something to be, we can always bring a kind of a supplement leaflet or booklet saying that these are the updations now, these are the changes. We will be very happy to do that, not an issue at all. That is the beauty of IGNOU material, that we can keep on continuously updating it by supplements, by we learn every day, we learn from our experts, from our students also, because all our students are adult learners. So we have no problems in accepting that there are some changes, there are some other versions which we also would like to share with our students. Not a problem at all.
Thank you, ma'am. Thank you, sir. Thank you for insight.
Ma'am, will you be sharing?
Questions are the same ones.
I didn't understand. What did you say?
Pre-counseling and post-counseling, the
They
questions
are always the same. That is the purpose of the pre and post counseling.
Okay.
They are always the same.
Okay.
So can we
Ma'am,
stop?
will the answers be shared of those two links which we
Yeah,
submitted now?
we will. Once we complete the post test, we will share with you the answers.
Okay, thank you.
So I can stop the counseling, the recording, and in the meantime, you can still ask for another 2-3 minutes if there is anything. Otherwise, we will relieve sir. He must be really tired.